Okay, good morning, everybody, and welcome to our webinar this morning on flexible furlough and what you need to know for July and beyond. For those of you who don't know me, I'm John Hales. I'm head of the employment team at Womble Bond Dickinson. I'm joined this morning by my colleagues, Charlotte Bloomfield and Jane Flint. Charlotte is a legal director in our Southampton office, and Jane Flint is an associate in our Leeds office, although along with myself, we are currently working remotely at home. And both Charlotte and Jane have been advising clients extensively over the last few months on the employment law implications in respect of COVID-19. The timing of this webinar is very timely, obviously, as it's the 1st of July, and there's a number of new considerations that we've all got to be taking into account now. So in terms of what we're doing today, there's 5 main topics that Charlotte and Jane are going to be covering. Firstly, details of who you can claim for after the 1st of July, the contributions you'll need to be making from August, details around some of the changes that are currently taking place and the steps that you might want to be thinking about taking now. And probably most of the detail today is going to be in relation to bringing employees back on a part-time flexible furlough type arrangement, and we're starting to advise clients quite a lot on that particular issue now. And Jane and Charlotte will try and get into some of the detail around that, so around perhaps some structured returns to work, picking up issues around holiday risk assessments, communication with employees, and perhaps then also some of the issues around less structured returns, if I can put it in that way, where workloads are more fluid, challenges around communications and consent, and what if actually somebody refuses actually to return to work. So Charlotte and Jane will take you through all of those issues. We'll have a Q&A session towards the very end of the presentation and webinar this morning. But Jane and Charlotte, we've received a number of questions before this webinar, and both Jane and Charlotte will pick up some of those questions that they've had already as and when we go through the presentation. So we'll kick off shortly, but before we start, a couple of housekeeping points. This session is being recorded and we'll distribute it afterwards for everybody that's joined, but we won't be referring to names or organisations when answering questions, so everybody will remain anonymous. In terms of how to ask a question, the Q&A feature should be visible in your right-hand panel on your screen. To expand this, simply click the right-hand arrow. At the bottom of the screen, you'll see a free text field where you can type a question. Once your question is ready, press send. This will then go to Charlotte, Jane, and myself. And feel free to submit questions throughout the webinar. And as I said, we'll pick it up towards the end. If the Q&A panel isn't visible, I'm told you can click the More Options button on the control panel, which has 3 white dots, and the Q&A will then be an option at the top, and you click once to re-enable. I hope that's clear. We'll do our best to pick up and if as many questions as we can, but you'll understand that we might be limited in terms of the number we can deal with. But if there's a trend developing, I'll try and address 1 or 2 of the specific trends that we've got. We'll also be doing some polls during this session, just for everybody's interest in terms of exactly what we're seeing. So when we open a poll, it'll be open for about 30 seconds. You'll receive a prompt for you to answer. So I'm going to hand over to Jane in a moment in register to kick this off. But I just thought I'd throw open one question for you in terms of a poll. And it's the sort of thing which actually most organisations probably are now looking at. What do you think are your employees' biggest concerns regarding them returning to work? Is it the commute? Is it the risk of infection in the workplace? Is it managing childcare issues? Is it protecting a vulnerable person they live with? Or is it some other issue? So that's just the first poll, just to get people to start thinking about perhaps one of the things that we think as employers that employees are particularly concerned about. So that's all from me for the time being. Jane, over to you.
Thank you very much, John. Thank you, everybody, for joining us today. Thank you for making it. So I'm just going to quickly talk through an introduction to the scheme and how the flexible working arrangements will operate. And I'm then going to hand over to Charlotte, who will be talking about the increased contribution levels. So today is, as John said, very timely, the 1st of July. As of the 1st of July, the government has said that businesses can now allow their employees back to work as part of a flexible work arrangement. This is, of course, really, really beneficial for organisations who, over the course of the last few months, have had a very difficult task during lockdown. Businesses who have been trying to keep the doors opening, keep the lights on, trying to build their business up, have been presented with a very, very stark challenge between, do they put their workforce on furlough leave and take advantage of the job retention scheme and the government contribution under that scheme, or do they ask their employees to stay at work full time? There has been no halfway measure for employees, and that has made things very challenging. Luckily, as of today, you are afforded that flexibility. That means there are a number of options available to you. You can keep asking your employees to remain on furlough leave, or a proportion of your employees to remain on furlough leave, subject to the contribution level Charlotte will talk about in due course. You might ask some employees to return to work full time. Or you might ask some employees to carry out a combination of part-time working and furlough leave. So, for example, if somebody's normal contractual hours are five days a week, you might ask them to return 2 days a week and to carry out furlough leave for the remaining 3. You can also ask employees to partake in, well, you can actually instruct employees that they must also take some annual leave. That is an option available to you under the working time regulations. The only caveat with that is the regulations do say you must give employees twice as much notice as the amount of leave as you want them to take. So, for example, you might say to somebody you want them to work 2 days a week and you want them to be on furlough 2.5 days a week, and for the other half a day, you're going to instruct them to take half a day's annual leave, to utilise some of the annual leave that they're not going to be able to take when they come back to work during this corresponding annual leave period. Now, for an employee to be eligible to partake in furlough leave going forward, it's very important to remember that that employee must have been furloughed for a minimum of 3 weeks under the furlough leave scheme prior to the 30th of June. So what that means is that somebody must have been furloughed. You'll remember when furlough first happened, the government said you must furlough your employees for 3 weeks to take advantage of the government scheme. So that person must meet that criteria to be eligible for furlough leave from the 1st of July. That doesn't mean that person must have been furloughed up until the end of June. It might be that they were furloughed up until the beginning of June and then they've come back to work full time. But provided they were at some point during the lockdown furloughed for 3 weeks, they will be eligible for this flexible work arrangement going forwards. You will be limited to people to the maximum number of claims that you brought previously. So say you made a claim for 30 employees one period, and then you made a claim for 60 employees, 20 employees went back to work, and you then made a claim for 40 employees. Going forward, you will be limited to making a claim for only up to the maximum amount, which will be 60 employees. There is an exception, and that is anybody who is returning from maternity leave or paternity leave. Those people will be able to return to work even if they weren't previously furloughed, and they will be in addition to your statutory cap. The scheme, the way in which you apply for the scheme will change, and that will be quite crucial for you. I'm going to talk to you about that in due course, but before I do, I'm going to hand over to Charlotte, who's just going to talk you through the increased contribution levels. Thank you.
Thanks, Jane. Good morning. So July remains pretty much the same as it has done to date. So the government contribution will remain at 80% or up to the cap of £2,500 per employee per month. And the contributions to employers, national insurance contributions and minimum auto enrolment pension contributions will also continue. With effect from the 1st of August, though, the employer becomes responsible for those employers' national insurance contributions and minimum auto enrolment pension contributions, but the contribution that the government makes towards the salary remains the same, so 80% or £2,500 per month per employee. From September, 1st of September, that's when the contributions, the bigger contributions start, and the government contribution towards salary reduces. So from the 1st of September, it's 70% or up to £2,187.50p. And the employer will then be required to make a 10% contribution or up to £312.50. So effectively the employee gets the same amount as they did prior to the change. They see no difference. It's just that the contributions in the background are split differently. And employers are also responsible again for national insurance contributions and auto enrolment pension contributions. From the 1st of October, the second reduction in government contribution is implemented, and that will see a reduction to 60% or £1,875 per month per employee, and your employer contribution towards furlough will be 20% or up to £625. And again, national insurance contributions and minimum auto enrolment pension contributions. And from 1st of November, the employer will become liable for 100% of payroll as before. Now, when you are using flexible furlough, there is an expectation that you will continue to pay your employees their contracted wages at the contracted rate for the hours that they work for you when they are not on furlough. And there are some relatively complicated calculations for ensuring that you're only claiming for the correct amount when you have people on flexible furlough. And there are plenty of examples of that in the government guidance, some worked examples, which I'm sure are very helpful to those who are responsible for sorting out those contributions. Now, we've had a webinar question around redundancy, which kind of ties in with this point of the reduction in contributions and whether or not you can make people redundant during the furlough period. Generally speaking, there has been an acceptance that when the contributions, so employers start having to contribute, there will be possibly a reluctance or an inability of employers to continue to keep people on who would have been made redundant but for furlough leave and for the job retention scheme. And therefore, we are certainly seeing that employers are linking notice to furlough and that people's termination dates are falling within the period of the job retention scheme. What we would say is it's really important to be clear about the reasons why you are making those redundancies and the state of your business's finances when determining at what point you are going to make somebody redundant and their termination date falls. There's clearly some benefit to employers having people, even during the period where there's the tapering, of having notice periods run during furlough, because the financial contribution towards that is still less than making a payment in lieu of notice. But we also understand that some people will find it financially difficult to continue to employ people once employer contributions are required. And now Jane's just going to run through the changes to the way in which claims are going to be made.
Now, I have got the very, very dull task of talking about the changes to the process that you need to make under the scheme. So under the scheme, there are a few changes to the way in which you need to make your application. So I'm going to be talking you through that, and I'm secondly going to be talking you through how you actually calculate your hours of work, because if you're asking somebody to come back under a flexible work arrangement, then there is a certain way in which you must calculate their outstanding furlough hours for the purposes of making a claim under the scheme. So I'm going to talk you through that. It's a bit dull, but I'll try to make it as interesting as I possibly can. The first thing for you to be aware of is that there's essentially a line drawn in the sand. So from the 1st of July, you will be making a claim for that respective period, and that will be that period in July. The government has said that you cannot make a claim for to cover consecutive months. So you can't, for example, make a claim to cover for an employee to cover the last 2 weeks in July and the first 2 weeks in August. You can only make claims to cover July and then other claims to cover August and so forth. What that means, of course, is that any employees who were furloughed up to the end of June will then need to be almost entering into a new application as of the 1st of July. So basically it will be a new period. You've got until the end of July to make any claims for people up until the end of June, so that's absolutely fine. So that's really important to remember. Now, the second thing for you to be aware of is that you can only make one application in each period, and that will, of course, to cover that 1 month period. You can only make one application to cover your entire workforce. You can't make multiple applications. That's really, really important, and that's going to be challenging for some businesses, particularly if you've got, and Charlotte will come on to this in due course, but you've got employees who, maybe you've got a business where you're a contractor, you provide work as and when it comes in, and you just don't know when you're going to be able to ask your employees to work. So you need them to agree to work flexibly. You're not going to be able to make separate claims for those people. So that will be logistically challenging for some businesses. Now, the government has said that you can actually make an application, or you can make a claim for your workforce up to 14 days before the end of that claim period. So say your claim period ends, and I'll come on to what claim period means in a moment. Say your claim period ends at the end of July. You can make a claim 14 days before the end of July. The reason for that is to enable businesses to make the claim and get the money in before payroll actually arises, because the government recognises that for some employers you will need that money coming in to be able to pay your staff as part of your usual payroll measures. Again, you know, for businesses who are needing a more flexible work arrangement, that won't be possible. That will only work for businesses who absolutely know and can preempt in advance what working hours their employees will be carrying out. And so that will be a little bit logistically challenging. The way in which I'm just checking my checklist, sorry. The way in which you will make a claim under the scheme is that you will basically have to work out, and I've got my notes in front of me because it's a little bit, the government guidance is a little bit, they don't just say you've got to make a claim for your furloughed hours, you've got to carry out a certain calculation. And the calculation basically is that you must work out, first of all, the usual hours for your workforce. Now, the way in which you work out your usual hours is you work out the number, say as an example, you've got an employee called Fred and he works 30 hours a week and he earns £3,000 a month. If from the 1st of July you ask Fred to work half days a week, the first thing you must do for the purposes of making your claim is you must work out what his usual hours of work are before he was furloughed as of probably the 31st of March. So what were his usual contracted hours? They were 40 hours a week. And you must then divide that by the number of days in the work pattern. Now, it's important to realise that the number of days is actually defined as the number of calendar days. So if you've asked Fred to come back to work to cover Monday to Friday, the number of days will actually be 7 days, because that's the calendar day period. So you divide that by the number of calendar days, and you then multiply that by the number of days in the respective pay period that you're claiming for, which is 31. So you basically have 40 hours, you divide it by 7, which is the days in the calendar days, and you then times that by the number of days in the claim period, which is 31, and that gives you a average number of usual hours of 178. So you can see it's a little bit complicated in terms of how you work it out. What you then need to do is then you need to work out the furlough hours. You basically get the usual hours and you deduct the working hours, and that leaves you with the furlough hours. So the way in which you will do that is your usual hours, which in this case is obviously 178. And you work out your working hours. Well, in this case, we've asked Fred to work half day, so he's going to be working 23 days, half days, which amounts to 92 hours. So we then subtract that from the usual hours, which is 178, and that leaves us with his furlough hours, which is 86 hours, and they're the hours that you would be claiming for under the scheme. So that's how you work out your calculation. Now, I hope I've explained that in terms of making you see that when you look at the government guidance, it's really, really complicated, but actually that's how you break it down. So hopefully I've simplified it somewhat for you. That being said, there is lots of useful guidance on the government website with worked examples, and we've also got guidance on our website to help you navigate that too. Now, when I'm talking about the period, what am I talking about? Well, you may see that the period you have to claim for has to be a minimum of 1 week. What does that mean? Well, basically what that means is you must enter into a work arrangement with the employee to cover a minimum of 1 week period. So with Fred, for example, you must agree with Fred a part-time work arrangement to cover, so for example, Monday to Friday, that you're going to ask him to work half a days. With another employee, it might be that that period, that work arrangement might be that you want them to do 2 days a week and 3 days on furlough. It's up to you how you want to make that work arrangement work to suit your business needs, but it must cover a minimum of a 1 week period. It doesn't have to, it can cover any period you want. So it could be that you know you're going to ask Fred to come back for a whole month and he's going to be working half days. So your period would then be a month. But for some employees, you might be wanting to enter into a bit more of a flexible work arrangement. And in that case, then your claim period may be different. So it might be that you want somebody to come back on a rotational basis. You might want them to come back full time for the first week and then the second week go on furlough. So there you can see your first week and your second week, you're going to have different hours claimed for. So week 1, it's going to be their usual, but you're probably going to make no claim because they're back full time. Week 2, you're going to be claiming for their full contractual hours as part of your furlough claim. And in that case, you would have 2 separate claim periods. So that's when we talk about the claim period being for a minimum of 7 days, that's what we mean. But you must then amalgamate all of that for the purposes of actually submitting your claim to the government under the government portal, because remember, you will only get one chance to make that application for your entire workforce. So as I said previously, if you know in advance what your employees are going to work, you can make that claim in advance. If not, you will need to be making that claim retrospectively to account for the actual hours they have worked, less the amount of hours they should usually work to amount to what was less as their furlough hours. I hope that that's clear. That's it really, and that's basically the main headline issues in terms of the changes to the scheme itself. One final thing to say is that the government has said that when you only get one chance, you can amend your claim afterwards. So that's in a little bit of a grey area at the moment in terms of what you do, because the guidance is a little bit conflicted on that. And I will pass you over to Charlotte to carry on with the next part. Thank you.
Thanks, Jane. So just some practical steps that you should be thinking about taking now. You'll need to work out, as Jane's alluded to, the number of employees that will need to be furloughed from the 1st of July and check that they are eligible. You can actually claim in respect of those individuals, or at least that number of employees. And then you'll need to ensure that you are complying with the HMRC guidance and the government guidance around keeping records. So they are saying that for 6 years, you must retain records regarding the amount claimed and the claim period for each employee, the claim reference number for your records, the calculations in case HMRC needs to need a bit more detail about how you have arrived at the amount that you are claiming. Also, usual hours worked, including any calculations that were required for employees you flexibly furloughed. So following on from Jane's point there around how you calculate those. Actual hours worked for employees that you flexibly furloughed, and I'll come on in a minute again to that and touch on that. You need to decide whether or not you want to bring employees back flexibly and on what basis. Create an audit trail. It's the employer's always an employer's wish list that you keep an audit trail of everything you do in relation to employees. It just makes things a lot easier. But in this case, it's really important that employees are recording hours, even in circumstances where ordinarily you may not require them to, but you need to have that audit trail. Accurate records are kept, and you'd seek agreement from employees about their flexible furlough. and that you carry out risk assessments. Now, you may also be in discussions with the unions if you are unionised or you recognise a union in relation to that, because flexible furlough can be agreed collectively. Consider how you'll make payroll calculations, and you may want to also contact either your payroll provider or software provider, because I understand that there are sort of add-ons and things like that that can assist you with these calculations. Some people are finding those more useful than others. How will you respond? Consider how you will respond to employees who resist returning to work. And again, we'll touch on this in a bit more detail in a bit. Consider management of holidays during this further period of furlough. I think a lot of businesses are concerned that employees are going to return and then suddenly want to take lots of holiday at the point where they're trying to gear back up. Decide whether you need to make redundancies or whether they will be necessary. And your key question is, do you wait until you are at the point of 100% funding, or do you want to start that process now? And also consider what that will look like. So your planning phase for redundancy, is there going to be collective consultation requirements and the like. And now we're going to move on to the practicalities of bringing people back. And as John said at the beginning, Jane is going to talk to you about...
I think we might have lost Charlotte. I'm not sure if anybody can still see me.
Hello?
Hi,
yes,
Charlotte.
Can you hear me?
Yes.
Yes, I can see Charlotte. Yeah.
Okay. So I was just saying that Jane's just going to now talk about structured returns to work, and then I will deal with less structured returns to work. So over to you, Jane.
Thank you, Charlotte. Okay, so when the guidance has said that, or the government has said that when you are asking your employees to return to work under a flexible work arrangement, the first thing you must do is ensure that you have sought the agreement in writing of the employee to the work arrangement which has been agreed, covering the specified time period. As you know, because I have just explained it to you, that time period must cover a minimum of 1 week, although it can be for longer. It's the guidance has been a little bit confusing. You might see some guidance which says that you must, the first guidance which was issued by the government in typical government fashion said that you must enter into an agreement in writing with the employee. Subsequent government guidance then said you must enter into an agreement, not you must agree with the employee, you must enter into an agreement. So that's a little bit different to you must agree with an employee to you must enter into an agreement. And that set particularly lawyers wondering, does that mean that you must enter into a specific type of agreement? We don't think it does. We think it just means, as per what you have probably done previously, you must agree the work arrangement with the employee in advance, and you must ensure that there is a written record that that has been agreed. The usual way in which to do that would be to send the employee a letter and ask them to sign and return that letter to confirm their agreement. The reason that you are doing this, of course, is because notwithstanding the fact that the government says you have to, it's also essentially a variation to their terms and conditions, albeit on a temporary basis. But to ask somebody who has previously worked a contracted 40 hours a week, for example, to now come back to work 20 hours a week or 10 hours a week, that is a variation to their terms and conditions. So it's important to effect that variation in writing and to seek their agreement. Failure to do that amounts to a unilateral variation of the contract of employment. The government has said that you must retain a copy of that agreement in writing in your records for up to 5 years. So it's very important that you do that. So the way in which you go about doing that, we're going to come on to in a moment the thing that you need to do before you get to the point of actually having the conversation with your employee. But really, ultimately, it's all about speaking to your staff and consulting with them in advance and making sure that you have checked which employees are going to be able to come back to work full-time, part-time or not. Before you even get to that point, our recommendation is that you carry out a risk assessment. It's a legal requirement for you to carry out a risk assessment to ensure that you have ascertained any risks identifiable to the workforce as a result of them coming back to work emanating from COVID-19, and that you're able to implement the appropriate measures in place to ensure that they can socially distance, that you've got suitable hygiene measures, that there's suitable hand washing facilities. And the government guidance does say that you should carry out a risk assessment for each particular group of worker or each particular category of person who is going to be differently affected. So if you've got, say, for example, a group of welders who work in the garage, and you've got a group of office staff who work in the building next door, you'd be doing different risk assessments for different people under different working conditions. And that's just common sense, really. When you've done the risk assessment, you of course want to be assessing your business needs, and I'm sure most of you have already done that. How are you going to be able to get your employees back to work versus any financial difficulties that you may be having at the moment? Are you needing to look at long-term redundancies? How does that fit in with your short-term plans? Make sure, of course, that you have given consideration to the tapering of the government contribution levels, which Charlotte described to you earlier, as part of your upfront considerations. Because you will be required to make an increased contribution towards the cost of people on furlough leave from the 1st of August, and that might impact on your plans going forwards. Consider if you need to consult with appropriate representatives. If there are over 20 employees or more affected and there is a risk that they could be dismissed and re-engaged, or there is a risk of redundancy, then you will need to consult with the appropriate representatives. Charlotte will come on to the mechanics for that in much more detail, but that's certainly a consideration that you need to be giving upfront, and if so, you do need to be starting that consultation with the employees. And then, of course, you need to be having a discussion with the individuals. Now, before you've actually got to having that conversation with the individuals, it would be really helpful to know what the personal circumstances of those individuals are, because some individuals will be in certain categories which might make it more difficult for them to return. A good way to do that, for example, is to maybe send people a questionnaire. I mean, you can ask everybody in advance, you can speak to everybody individually, but if you have a large workforce, it might be helpful to send people a questionnaire and ask them the usual questions. You know, you can say this is what we're proposing to do, or you can just ask them the questions as part of a generic questionnaire. Do you live with a vulnerable person? Do you have childcare responsibilities? Are you looking to return to work? Are you looking to work from home part-time? That kind of information up front will be really helpful in affecting you to kind of plan in advance before you actually have those conversations. And what it will also do is help you to identify which employees you want to ask to return. Now, you probably won't want all of your staff to be returning to work, or you might want people to be returning on a rotational basis. But for most businesses, they will probably want to still keep some people on furlough leave. So, for example, if you've got 4 engineers in your business and you only need 2 back, how do you select which 2 you're going to ask to come back? Well, you can just carry out a usual objective matrix that you would almost in a redundancy situation. It's really important that what you don't do when you're selecting the people to come back is you don't act in a discriminatory way, either in asking them to come back. So, for example, assuming that somebody can't come back and asking the other people to come back because of their personal circumstances could potentially be discriminatory, or the other way around, asking somebody to come back when their personal circumstances mean that it's very difficult for them to do so. So that's why actually having that information up front about people's personal circumstances could be helpful to affect that decision. There will be certain people when you're making your decision about who to ask back who just simply are going to struggle for their own personal circumstances, for example, because they've got childcare responsibilities, or maybe because they're in the vulnerable category or the extremely vulnerable category, or they're living with somebody who is vulnerable or shielding. With those people, Charlotte will come on in due course and talk about the ramifications and the difficulties with actually having those conversations and what you can do about disciplining those people in that course. But ultimately, you can ask those people to come back if they have childcare responsibilities, or if they have if they are living with a vulnerable person. but it might not be so easy for them, particularly up until September when the schools are opening, and even after that. So you do really need to see whether there's other arrangements you can put in place with them. And the government guidance is really clear that before you instruct people to come back, you really must be doing everything possible to try to find alternative solutions if they're unable to do so. So, for example, asking them to work at home, keeping them on furlough if that's necessary, and other measures which Charlotte will come on to in due course. There's been a little bit of confusion in respect of the vulnerable grouping. Now, the vulnerable grouping from August will be able to come back to work. And the guidance, the government guidance does say, quite confusingly, I think, that you can, people in the vulnerable category will be allowed to come back to work from the 1st of August. I think that's a little bit unhelpful, because if you look at other government guidance, it then says that vulnerable people need to be considered separately, and you need to consider other alternatives for them, such as keeping them on furlough leave. It comes back to the fact that with vulnerable people, ultimately, if somebody is saying to you, look, I'm a vulnerable person, I have a health condition, or I'm living with somebody with a health condition and I'm worried about returning to work, as an employer, you must act reasonably in giving consideration to that concern. Because if somebody reasonably is concerned about their health in returning to work, even if they're not a vulnerable person, if they're just genuinely and reasonably concerned that their health might be impacted by returning to work, that might afford them protection under Section 100 of the Employment Rights Act. So any on health and safety grounds. So any subsequent detrimental treatment, such as disciplinary action, could be deemed to be a breach of your employment obligations towards that person. So it's a really difficult area of law where people say, I can't come back to work. Unfortunately, I'm really worried about my health, or I'm really worried about the health of someone I live with. Now, if you have carried out your risk assessment and you have identified these people and you have consulted with the representatives and you have identified as part of that risk assessment that you have put appropriate measures in place and they can come back to work, that will put you in a really good position to have a sensible conversation with them. But by that point, you should have been able to identify that category of employee versus a category of employee who does genuinely have concerns, and you might need to make separate arrangements for them. So that's the measures in place in respect to asking people to return to work as part of an ongoing and standard work arrangement. Make sure that you have sought their agreement in writing in advance. Make sure you've discussed the matters with them, and make sure you've kept a copy on record for 5 years. Charlotte's going to talk about the much more difficult issue of asking people to return to work as part of a variable work pattern or a rotation work pattern. And I'll pass that over to Charlotte to talk about that. Thank you.
Thanks, Jane. So what if your business does not have the work to justify a structured return to work pattern? And what if your workforce simply cannot work from home? This is a question that I've been advising on quite a bit in recent weeks. And there are a lot of businesses out there who are envisaging a more fluid approach to flexible furlough. You could almost call it very flexible furlough, where work is sporadic, but the business is trying to weather the storm. They want to keep customers happy. They want to and deal with small pieces of work as they come along, just to tick over. And they could be, for instance, businesses particularly affected because they're linked to the holiday and leisure industries, and also who provide manual labour. So what will they do? I'm being told by some of my clients that they will bring back employees as they are needed, dependent on the work that has been won and the tasks that need to be undertaken during a project, however big or small, and based on employees' specific skills. So it could be for as little as an hour in an entire week, and possibly between now and October, just the single hour, or it could be a few hours, or it could be that they are required to come back for a week at a time and then go back off on furlough. It really genuinely is dependent on the work, and clearly that's less than
I can still see myself, so I'm hoping other people can see me. I'm not sure.
Can you back? Yeah, I think there was a bandwidth issue. Apologise. Clearly, to be very flexible is less than ideal for both employees and employers. I mean, I think payroll departments will possibly be tearing their hair out with the calculations they have to do, and clearly employees may be slightly more anxious about coming back in a less structured way, whilst perhaps we envisage them just sitting at home having a lovely time. That may not be exactly how it is, and they may have plans and childcare responsibilities, etc. But ultimately, I would say communication is key in all of this, and that is certainly borne out in the guidance from the government. There is an expectation that employers will be talking to employees. We appreciate that where your business is a larger business and you have many employees, that won't be that simple, possibly. But there are ways and means that you can make sure that team leaders and everybody is communicating as best they can. And it might be that you have one letter that basically says, we can't predict what is happening, but your line manager will be in touch with you regarding when you may be required to come off furlough and work hours, etc. And I've certainly drafted something along those lines. It's really important to explain to employees why you're doing or proposing what you are proposing, because they will often get on board far better if they understand the underlying reasons, i.e. potentially, the bleak reality is that you wouldn't have a job at all at the end if we don't just keep things ticking over. And as Jane has said, we need them to agree and accept the flexible furlough, and they should be encouraged to talk to you about any concerns they have about returning or the pattern that you're proposing, etc. You need to explore and have that conversation with employees about whether or not they are unwilling or they're unable to return to work and what those underlying reasons are. You need to identify those, because ultimately, if you find yourself in tribunal, the context is critical to avoiding claims or being able to defend claims that are brought. We fully anticipate seeing an increase in claims on the grounds of discrimination, whistleblowing, and health and safety detriment claims, which is just entirely COVID related. So as Jane has referred to, people may have caring responsibilities, because remember, not all schools are back, and even when they are, they can be restricted hours. All the different schools are doing different things dependent on their physical capability to take children in. People may be shielding or living with somebody who is shielding. They may have health and safety concerns. You may not consider them to be reasonable, but you need to have discussions. You need to be sensitive to people's concerns and try to talk to them and encourage them to come back. And be sensitive to employees' concerns, not only for that reason, but also because it is anticipated that the instance of anxiety and illness related to anxiety will increase. So it may be that people end up going off sick or need to be referred to occupational health to be assessed, because anxiety can amount to a disability. And keep an open mind. Make no assumptions about people's personal circumstances. I've certainly advised in response to vulnerable people saying, I want to be back at work. I don't care what the guidance says, I want to be back. But equally, there are those who don't want to return. If you can't persuade an employee to return to work, you need to have a sort of a toolkit of things that you may consider. Disciplinary action is probably the last of the actions that you would want to consider because of the potential risk of claims. But can people with caring responsibilities take parental leave or carers leave, unpaid leave? Have they got holiday to take? Is there alternative work that you could get them to undertake? Can you agree to do a personal risk assessment in relation to that individual so that you can have another discussion with them and try and persuade them to come back? Or is it an OH referral situation? You could stop pay, you could insist that somebody returns to work and then take disciplinary action. But as I've just said, you then risk potential discrimination claims, indirect sex and disability discrimination, possibly automatic unfair dismissals or detriment claims for health and safety on health and safety grounds, or whistleblowing claims. So again, it's really important to be listening to why your employee is saying that they cannot or will not return to work, because potentially they will be afforded whistleblower protection. You also owe an implied duty to take reasonable care of the health and safety of your employees, and plus the standard implied duty of mutual trust and confidence. So you could find that you have constructive dismissal claims where employees feel that they're not being listened to and resign because of the action you're intending to take. So when you decide who you want to bring back, as Jane said, it's worth having your objective justification for who you have chosen, and your survey would be really useful there. And it may be that somebody's skills mean that they can't do anything else, or you need their specific skills, and then it's about trying to make their work environment or their travel to work. So for instance, it might be that they are concerned about having to travel to work by public transport, and then you might want to make arrangements for car parking spaces, etc. So you just need to try and think outside the box and make sure that employees feel that they have been listened to. I was quite surprised when I was asked about international travel, because some employers are being required to send employees abroad in order to carry out the work that they're undertaking. And again, it's about number one, following the government guidance at that date. It's constantly changing, so you need to keep abreast of that. Talk to the employee about any of their concerns, encourage them to tell you if they arrive on site in another country and they have concerns, make sure that that's all covered. And then when they come back, at the moment, of course, they would need to remain in self-isolation for 14 days. And I suspect that most employers would place that person on furlough for that period, given that that is work-related travel. But you also need to consider whether or not it is essential. Now, sometimes that will be, because that's the only way that that contract is going to be fulfilled. So in summary, we have covered, clearly galloped through the changes in furlough and contributions. And I think our main takeaways from this are just keep a really good audit trail of everything you're doing. Keep yourself up to, as much as you can, up to date with the government guidance, and take advantage of the worked examples that the government have provided for calculating hours, etc. And just keep talking to your employees. Clearly, there will be some who do not want to talk to you, and they would need to be dealt with separately, and maybe different approaches need to be taken with those people. But communication here is absolutely key to keep everything on track. I think we're now going to take some questions, John.
Thanks, Charlotte. Thanks, Jane. Charlotte, I've been keeping an eye on some questions, both ones we've had before, ones we've had whilst it's been going on. Can you just touch, Charlotte, a little bit more on the, you used the phrase unable to return to work, and somebody's asked a question around care. Somebody's been providing childcare for another family member because you're available. Is it reasonable to say you can't return when the employer asks you to do so? What sort of things do you think an employer would take into account when, again, dealing with that type of issue, actually been providing childcare for another family member? I mean,
well, it's about having a conversation. I've got a lot of social distancing concerns, and why are people looking after other people's children? One assumes they must be in the same household or in a separate bubble. That raises more questions in my head than just the simple question of how, as an employer, do you deal with that? I'm aware that some key workers have still had their family members continue to help because they haven't wanted to put them into child setting, or the settings haven't been available. So I think it's about unpacking why that is necessary and why that employee can't do it. And then it's a case of saying, well, okay, if you want to continue doing that, it may be that we need to place you on unpaid leave. And that is the consequence of you agreeing with your family member that you're going to look after their child. But yeah, it's very much having a conversation.
Yeah. Jane, you were touching earlier, and we had a couple of comments around section 44, section 100 in terms of what do employers need to think about, if they get employees that are starting to say, actually, I don't feel necessarily safe to return to work. You touched on sort of risk assessments and other things like that. Are there other things which employers need to be thinking about in those circumstances?
So the first thing, of course, is to ensure that you have, and I've gone back to it previously when I spoke about this, but to make sure that you are comfortable that you have a really robust risk assessment in place that identifies the risks for that particular category of employee. Now, that risk assessment should identify any potential health and safety issues and how you have managed to address those issues. Now, if somebody says to you, I'm worried about returning to work, because I'm a vulnerable person, I'm clinically vulnerable, then they're going to have a much stronger argument for them being concerned about their health than somebody who doesn't fall into that category. And of course, it's worth saying that somebody who lives with somebody who is vulnerable would also have a genuine concern. The problem with the government scheme in accordance with section 100 is that for somebody to bring a claim, or somebody to fall within the ambit of protection under the Employment Rights Act, they just need to have a genuinely held reasonable belief that their health and safety could be at risk, and the statutory wording is a reasonable belief that there could be an imminent risk to their health or an imminent danger to their health. And unfortunately, the word danger and imminent is actually quite widely construed. I mean, if you said to me, is there an imminent risk to a danger to your health? I would think that means, something really, really, am I going to fall off my chair now and collapse? But it's much wider than that. So because of that, and because of the way of the wording of the legislation, that doesn't mean for employers that where somebody raises this as an issue, even if they don't fall within the category of being a vulnerable employee, you really need to be seen to be addressing their concerns and not just address, let's say, well, this isn't important to us. You must be seen to take all consideration about their concerns, because if you don't, then you haven't addressed whether or not their concerns are reasonably and genuinely held. Now, if you get to the end of that but you've been able to show that person how you've been able to put their concerns at rest, but they're still not able to come back to work, then it's likely that they're no longer falling within the category of protection under section 44. And it might be that you now need to start moving the conversation towards this is a lawful management instruction. But there's a massive grey area in between, in which you as a business are unfortunately very exposed and very vulnerable to the risk of a claim.
Thanks, Jane. Thanks, Charlotte. Very helpful. I'm conscious we're approaching the end of the webinar. We had one, and actually it's been supplemented by a similar question on the Q&A around, with talks of a second wave of this pandemic, are there any plans for furlough to be extended through such periods? Now, I thought I would just take that in terms of bringing everything to a conclusion. Latest figures of this, the furlough scheme is currently cost at around £58 billion. I'm sure that figure has changed. I would be astonished if later in the year, early next year, the government were in a position to offer any additional financial support if we do have a second wave at some point. So I think what is going to happen is that clients are going to need to start looking now, as they are, at restructuring generally. And I think it's fair to say that Charlotte, Jane, myself, and the rest of here are starting to deal with that now. And for larger organisations, there are obviously the collective consultation issues which need to be considered now, whether it's 30 days or 45 days, depending on the number of redundancies. So what we are planning on doing moving forward as a firm is we'll be holding a further webinar in the next 2 or 3 weeks around redundancies and the issues that organisations need to be thinking about now, because we have no doubt that we're seeing it in practice that this is something that organisations will need to be looking at. They haven't done it already, they'll be looking at it soon. So that's something which we will be picking up soon, and I suspect, and I don't anticipate that there'll be any further government money later in the year or during the course of next year if we get a second wave, and therefore planning for those types of eventualities and potential restructuring redundancy is clearly something which is relevant now for all employers. So thank you for everybody that's joined us today. We've had a fantastic response to this webinar and the other webinars we've been running. We will circulate a recording of the session later in the week, but actually on our website we've got our Restart Britain hub, which has got lots of information around not only actually employment issues, but other pension issues, health and safety issues, and other issues in other areas of law, which will be relevant for the organisations that you work in and you work with. So we will, as I said, be doing another webinar around redundancies, and actually we will also be running a webinar with one of our health and safety partners around the health, safety and wellbeing considerations of those who will be returning to work, but interestingly those that actually for a medium or longer term will actually be wanting to continue working from home, because there are some very interesting issues both in terms of risk, health and safety, best practice and insurance on issues where people continue to work from home for a longer period of time. So those are the types of issues we'll pick up in the next few weeks, and we're certainly doing both of those webinars during July. So to do is to thank Jane, thank Charlotte, and thank all of you for joining us. And we look forward to you joining us for another webinar in the next few weeks. So thank you very much from me. Thank you.
Thank you.
Thank you. Thank you, John.